I think I show that by the emails of David Arod in the fact that by policy or custom or whatever would allow him to create such a ethics violation such as funneling everything to his desk after he has been named as a defendant is a real issue here. So
You're basically right, and Fredrickson's conflict argument is weak to the point of being frivolous. Here's the straight talk version. 1. There is no concurrent conflict under Rule 1.7. Rule 1.7 only applies when a lawyer is representing multiple clients with competing interests or when the lawyer's duties are materially limited by some other obligation or personal interest. That is not happening here. Ayraud represents the county. He represented the county in the first lawsuit. He continues to represent the county in the new lawsuit. There is one client, not multiple. There is no adversity between clients because there is only one client. That alone kills the Rule 1.7 argument. 2. Being named as a defendant does not automatically create a conflict. Plaintiffs love this move. I sued you, so now you're conflicted. Courts see through it. A party cannot manufacture a conflict simply by naming opposing counsel as a defendant, especially when the alleged conduct arises from the attorney's representation of the client, and the claims are duplicative or substantially similar to claims already dismissed. If that tactic worked, every losing plaintiff could disqualify government counsel at will. Courts do not allow that. 3. This is the same subject matter, same role, same duties. Ayraud's role did not change. He defended the county before. He is defending the county again. The new lawsuit is substantially similar to the first, which was dismissed. His actions were within the scope of his official duties as county attorney. That means no divided loyalties, no personal interest conflict, no material limitation on representation. Courts routinely hold that continuing representation in a related or refiled case does not create a conflict. Hash 4. Notice of claim changes nothing. Fredrickson giving notice of an upcoming lawsuit and the county contacting its attorney is normal, required, exactly how government litigation works. That sequence does not create a conflict. It shows the county acted properly. 5. Professional conduct matters, and it favors Ayraud. You noted something important. Ayraud conducted himself professionally in the first case. That matters because disqualification is an extraordinary remedy. The burden is on Fredrickson to show a real, specific conflict. Courts do not disqualify counsel based on speculation, hostility, or retaliation. There's no evidence of misconduct, no adverse representation, no ethical breach. Bottom line, no sugarcoating. Rule 1.7 does not apply. Fredrickson is trying to weaponize ethics rules. Naming the county attorney as a defendant does not force recusal. This looks like a tactical harassment move, not a legitimate conflict claim. If anything, it strengthens the case for dismissal or sanctions if he keeps pushing it. If you want, I can tighten this into a court-ready argument, draft a response to a motion to disqualify, or help frame this as part of a pattern of abusive litigation conduct. Short answer, yes, but with an important nuance. Here's the clean, no-nonsense breakdown. 1. Conceptually, yes, written consent covers it. If ayraud is representing the county and also defending himself in his official capacity for acts taken as county attorney, then any arguable conflict is waivable, not automatic. Written, informed consent from the county neutralizes the issue under Rule 1.7b. And practically speaking, the county is his only real client. His interests and the county's interests are aligned. The claims arise from the same conduct, same role, same defense granting. That fits squarely within 1.7b(1). 2. But here's the key legal reality most people miss. In many jurisdictions, this doesn't even require consent, because a government lawyer sued for actions within the scope of employment is not treated as a separate client. The real party in interest remains the county. Indemnification statutes and official capacity doctrine collapse the interests into one quote. Courts routinely allow, open quote, county attorney represents the county and himself or another county employee when all defendants' interests are unified, close quote. So Fredrickson's argument fails even before you get to consent. 3. Filing written consent is a strategic shield, not an admission. If ayraud obtains written consent and files it, it preempts the conflict argument, it does not concede a conflict existed, it shows good faith over compliance with ethics rules, it cuts off the disqualification motion at the knees. Courts like that. 4. When this would not be allowed, and this isn't it would only be a problem if ayraud's conduct was outside the scope of his duties. The county might assert claims against him. He had personal exposure that diverged from the county's defense. None of that appears to be true here, especially given the first case was dismissed. Bottom line. Yes, written informed consent lets him represent both. In reality, he may not even need it. Filing it anyway is smart lawyering. Fredrickson does not get to force recusal by naming counsel. If you want, I can help you. Draft a one-page ethics disclosure consent that's bulletproof. Or outline a court response explaining why no consent is required at all.